Hello, everyone, and welcome to HR Options webinar series. My name is Amy Julian, and I am the Vice President here at HR Options. And it is once again my pleasure to be your moderator for today's session, where we are fortunate to have two incredibly knowledgeable speakers with us to review the complicated topic of leaves of absences. I will introduce you to both speakers in a moment, but first I have a couple of housekeeping information that I want to go over. You're welcome to submit questions throughout the session when you think of them by typing into the Q&A box on your screen. We're going to take all the questions at the end of the session. And for those of you who are looking for the Certificate for Continuing Education credits, or if you'd like to print out the slide deck, you can go to the Resources window. It's on the left side, middle part of your screen. You'll also find there documents that summarize leaves to help you in the future and some other valuable information. And lastly, there's an evaluation widget at the bottom of your screen, and we would appreciate it so much if you could just take it. There's, I think, 6 questions. It takes about 3 minutes just to respond to those questions. If you have to leave early, it's not a problem. You can complete it at any time. It's that we use your feedback to help us develop future training sessions, so it's extremely valuable for us. So why does HR Options offer the webinar series? Well, it's because we truly believe in value-added services, and we pick topics that are of interest to our contacts. HR Options offers outsourced HR support for small, mid-sized companies typically who need part-time or project HR support. We also offer outsourced employment services throughout the U.S. and Canada, so our clients refer us the workers they know they want to use, but they don't want to hire directly. So your workers on our payroll. We're just providing various tools that companies need at different times. We're meant to be a strategic partner for you. If you have any questions, give me a buzz. And now on to the main event. It is my pleasure to introduce to you our two speakers. First is Jeanine DeBacker, employment attorney and partner with McFarland, Spinkeles, and Thomas LLP here in the Silicon Valley. And her expertise is in employment law, and Jeanine has worked with HR Options for well over 10 years now on everything from employee relations issues as well as compliance issues. Joining her is Sandra Paredes, Director Consulting Services for HR Options. Sandra has over 25 years of experience in HR and is what I refer to a walking encyclopedia of employment information. She supported companies from the startup phases as well as Fortune 100 companies and all of their complexities. So welcome to you both. Jeanine, I'm passing the mic over to you now.
Great. Thank you very much, Amy. So I'm going to start off by talking about the big laws, and I'm going to press forward, which is the Family Medical Leave Act and the California Family Rights Act. And it's kind of a primer. This is to just add to the alphabet soup that we always, that's what everybody who's given a presentation cleverly calls the alphabet soup of LOAs for the leaves of absence. I, as an attorney, deal with leaves of absence multiple times a week, even when I'm full-on in litigation mode and defending lawsuits. And the intersection of the FMLA and CFRA and PDL and all the other laws that govern protected time off. And whenever we're dealing with it, and this is going to be my mantra throughout whenever I'm talking and whenever Sandra's talking, the concept that we always go back kind of to the beginning. And while there are a lot of great programs and multi-day seminars about leaves of absence and FMLA and CFRA, it's hard for a human being to you can't anticipate every scenario, and every scenario that we get is kind of unique. And the key is always to go back to the beginning and go back to this, what we're going to kind of talk through today, because you really have to make sure you're meeting the initial steps of your leave of absence analysis because sometimes things look crazy and you don't know what to do, and you'll go back and you'll realize, well, you don't even have to pay attention to these laws, or, oh my gosh, we have to pay attention to these other rules. And so it's just really important to follow your process. Even when you're a 20-year veteran of the FMLA, you know you have to go back and look through the checklist. And that's another thing that I wanted to mention, that while it's complicated and there's always quirks and twists, the main skill set, I think, is just an attention to detail and the willingness to go back and look at every step that you need to take. Are the eligibility factors being met? And that's, I'm kind of talking in abstract right now, but as we go through this, I think it's going to be clear. And then you need to have the time and a system or process in place to do these things. And so sometimes that's you, sometimes that's an outside resource, et cetera. So, but here's the basics and why it's important. So the Family Medical Leave Act and the California Family Rights Act, some people say I think FMLA and CFRA. I'm usually not that creative with those things, so I just have to say the words. So what those are medical-related leaves or family care-related leaves and time off. And it's always important to keep in mind, I'm kind of talking fast because I'm getting really excited about this subject, because this is how you start off a Thursday, talking about leaves of absence, is the concept of protected time off. And what that means, which is at the basics, when you're dealing with your employees, and this is another thing to kind of go back into your Zen mode, is I'm dealing with whether or not an employee has the right to not be at work and not get paid, right? And then the real thing they get is the ability to come back to a job. And what job that is depending upon what protected right they're under. So, you know, sometimes you're dealing with people who they don't have any knowledge about HR or employment law, and they think that you're trying to force them to let an employee go off to Aruba for 8 weeks of fun in the sun, when really what we're talking about is unpaid leave to care for themselves or someone else. And it's something that the government has said is important, and therefore we have these rules. And so there's a wide variety of rules, and the big ones are on your screen. So if you have 50 or more employees, you have to be mindful of FMLA and CFRA. If you have, and as we'll talk about this, there's things that go into that as well in terms of eligibility for both the employer and the employee. And then Sandra's going to talk more about the Pregnancy Disability Leave Act, which I'm just going to say it now, and we'll say it again later. Sorry to spoil the thrill, Sandra, but the Pregnancy Disability Leave Act has no service requirement. Somebody shows up on day one and they get pregnant, they're covered if you have 5 or more employees. The Americans with Disabilities Act, FEHA, the Fair Employment and Housing Act, and then the kind of the new layer, which is California Sick Leave, which is on this screen, and it's one of our hybrid leaves because that's both protected time off and wage replacement. So the ones above are just time off, and then you have paid sick leave, which is actually some money that the employee can get, and then the kin care leave, which is another layer on top of time off and sick leave. That one law, the kin care leave came out, I think 10 years ago, and then the paid sick leave law came out, and there's still a little bit of a confusion as to how those things apply. So, I'm going to turn to the next page. And what the FMLA provides, the Family Medical Leave Act, is, again, it's up to 12 weeks of unpaid leave per year. So it's basically a time off with the right to come back to work. And the benefits, the one cost, well, that is me being a lawyer. Sorry, because I see the costs as whether or not someone will sue. There's the cost of not having somebody at work. Okay, so yes, that's true. You have somebody who's not actually at work, so that's a cost to your employer. But wages aren't being paid. The employer does have to pay benefits at the same level that were paid if the person was at work. So if you paid their health care premiums, then while they're out, you'll continue to pay them. If you paid a portion of their health care premiums, you would continue to pay that portion, and the employee would be responsible for their portion. And then when that person returns from their leave of absence, they get to come back to the same or equivalent job. And that's one level of the return to work right. So a same or equivalent job, and then other leaves have the exact same position requirement, and other leaves that we'll talk about have just you get to come back to a job. So it's important to keep in mind what the rights are when the person comes back, what leave of absence were they under. And then who is covered by this law? Well, as I said at the beginning, you have the second bullet here. If you're a private employer, meaning not a government agency or a municipality of the government, such as a water district or a sanitation district, if you're just a private sector employer, then if you have 50 or more employees for at least 20 work weeks in the current or preceding calendar year. If you are at 100 employees, you don't need to worry about all that other stuff. You've exceeded 50 employees. If you're a smaller employer and you're kind of going 48 to 52, then you'll want to take a look at your at least 20 work weeks if you want to test that portion of the eligibility. And then all public agencies and local education agencies, regardless of size, are covered by the FMLA. So the first step is, am I working for a covered employer when I'm looking to manage these leaves on behalf of my employer? So when it comes to FMLA, do I have that 50 employee threshold, or am I a public agency? And then when the employee is indicating, asked for, or showing signs that they may need time off that could be covered by the FMLA, and that's an important thing to say, and I didn't write a note about it, the employee does not need to say any sort of magic words like, I need to take a leave under the Family and Medical Leave Act. They don't need to know what it's called, and they don't need to say those words to you. It's your job, without asking for information about a diagnosis or personal information, your job is to kind of ferret out information to see if this is something that would fit under an FMLA leave if they haven't asked for that leave. So you can provide them information so that they will know that this leave might be available to them. And so then you just need to see, okay, this person, do they work for the covered employer? Are they actually your employee as opposed to the gardening company that comes to maintain the landscape of your campus? And have they worked the 1,250 hours during the 12 months prior? Again, some of you guys might be like, oh my gosh, I know this. I could just roll this off my tongue. But it's every employee, you want to confirm that, okay? Because if a person just started 6 months ago, do you want to have that person be covered under this leave? Or what's your policy going to be? Because that's an exception to the law. And then do they work at a location that has that 50 plus employees within a 75-mile radius? And then do they have a qualifying condition? And this slide lists those qualifying conditions. It's important to not want to play doctor. So we've put these items here, but we really want to rely upon, if they've said something like, oh, I need time off for a medical procedure, I need time off to care for somebody else for a medical procedure, you're really going to push off on them the certifying documents and let their doctor determine, and tell you enough information that they'll fall under this, as opposed to, we get a lot of situations, especially very experienced people, because this rodeo is not new to me. I think I just messed up that cliche, but hey, you know what? When I broke my leg, I was back on the job in 2 weeks, and this person claims they're going to need 8 weeks. No, that doesn't. We don't bring our personal, personal experiences into it in that way. Then the CFRA, because we are in California, and it's our own little fiefdom of awesomeness, there's this similar law called the CFRA that has the same eligibility rules as the FMLA in terms of time of service and covered employers and eligible employees. But there's a couple unique differences that as you move through dealing with someone's leave of absence, you kind of have to keep in the back of your mind. And they're listed here. So, right, registered domestic partners aren't covered under the FMLA. Married same-sex partners now are because they're spouses, but there's a lot of kind of gray area in that whole scenario. For a while there, I was talking about how we're going to probably do away with the RDP exception because we're on this new frontier, but now I don't know. So we still have this very unique exception. And then, of course, pregnancy isn't covered under the CFRA because it's not considered a disabling condition, but rather the baby bonding provision is where you get your CFRA. And there's rules about when you take baby bonding, how you can limit that intermittent leave when parents can go out and decide not to take full 12 weeks of baby bonding, but rather break it up into increments. And then the last two have to do with a part of the FMLA that really came into play during the George Bush administration for military leaves. So the extended FMLA leave to care for somebody who had returned hurt from a theater of war. That was, I believe it's 26 weeks to care if you're the next of kin. That's not under the CFRA. And similarly, the military exigency, when someone's spouse is called up to military duty, your employee gets time off to take care of things like fixing, making new child care arrangements, going to military meetings, etc. And so those things aren't covered under the CFRA. So when something's not covered under the CFRA, that means that when the person takes their FMLA leave, they haven't exhausted, they're not pulling down from their CFRA leave. So they will still have that potential leave available. And so if they need to take a time off under the CFRA, you'll go back and look at the eligibility rules again. And then let's see. I have 2 more slides. I'm going to punt it off to Sandra. But your requirements as an employer are, first of all, you want to keep in mind what you want to be in the position of is how do I help this employee and put these things under protected leave so that we have not hidden the ball in terms of their protections to take time off, because that's where employers get sued, is when they do not let people know about their benefits or they interfere with people's right to take protected time off. So your job is to provide the required notices, and there's sample notices that you can use. Keep people informed in writing. I know some people have the type of workplace where it's like, oh, we don't get bogged down in all that. We're not, so intent on paper and all those procedures of all those old fuddy-duddy companies. We just kind of were a family. No. You want people to be able to take a piece of paper home that tells them this is what I'm entitled to, and they can rely upon that. You need to maintain people's group health insurance as set forth in that prior slide in terms of the same level that it was when they're there full-time. And then you need to restore the person to the same or equivalent job and benefits. And then you need to maintain your records of their leave of absence so that if in 6 months they need to take another leave of absence, you'll need to determine, do they have the right to take, how many weeks do they have left in their 12-week bank? Did they only use FMLA? Or is there still CFRA leave available? What other leaves are available, et cetera? So you need to maintain records. You cannot, and you guys probably know this, I still fall into that trap of, oh, I'll remember. No, you won't. So especially if you have several employees, or I will say several, meaning more than one. Although you need to have 50 to fall under this law, so that's a bad joke. But that's the basics of your job as an employer. And then this chart, which is, when you print it out, you're going to be able to see it. But for now, it looks like it's packed with information, and you'll be able to get that information later. But it basically is just a nice, quick reminder of if you have people going out on certain types of leaves, what notices are you required by law to present to them? So this is kind of like a resource for you to use, but it's just a quick reminder. If someone comes in and tells you that they're pregnant, and it doesn't matter if you have 6 employees or 600 employees, you want to remember to go down the third column from the left, the second column from the left, and talk about the, just a reminder about their rights under the pregnancy laws and how that interacts with the California Family Rights Act. So this is a great slide to kind of keep with your leave of absence information. What notices do I need to give to my employees so that I've satisfied my burden under state and federal law to let them know what they're entitled to? Okay, and now I'm turning it to Sandra.
Thank you, Jeanine. So I am going to speak for a few minutes on pregnancy disability leave. And the first thing I wanted to remind everybody is that pregnancy disability leave is for when the employee is disabled due to the pregnancy. This is not the bonding time. It is completely separate. So who's eligible to go out on pregnancy disability leave? Well, it's employers that have 5 or more employees, and there's no eligibility requirements on the part of the employee. So like Jeanine mentioned previously, if you have somebody who's been with you for 3 months and they work 2 days a week and they are pregnant, they will be eligible for PDL under the regulation. Now, what are they eligible for? Well, it's potentially quite a bit of time. They may take up to 4 months, which is 17 1/3 weeks of time off for disability relating to the pregnancy. So I'm going to give you a quick example of what a quote-unquote normal pregnancy, and then where maybe the 17 1/3 weeks are exhausted and we may need to provide even some additional time. So under a normal pregnancy and delivery, the employee can take up to 4 weeks off before the birth of the child and 6 weeks after, and this would be covered under PDL. If they have a C-section, it would be the 4 weeks before and then 8 weeks after. So if you have an illness or complications with your pregnancy, it could be the 17 1/3 weeks and some additional time. And an example of that, and it's an extreme example, but let's say an employee has to be on bed rest for 4 months. Well, the 4 months is 17 1/3 weeks, and they've exhausted their PDL, but they haven't had the child yet. So once the child is born through, let's say, a normal delivery, they have 6 more weeks, and most likely that time is going to fall under the ADA and the FEHA. And it's just, we just want to remind you that if they're out more than the 17 1/3 weeks, it does not dilute their baby bonding time under the CFRA. Like the FMLA and the CFRA, PDL has provisions for continuing medical benefits, and up to a few years ago, there was not the obligation. So you just want to make sure that if somebody is going out on PDL and FMLA and CFRA, there are some additional obligations, and the amount of time that they get covered for their medical benefits is longer than what it previously was. As Jeanine mentioned, there are required notices under the DFEH, and if you refer back to the previous slide, that will outline what notices are required. And again, just one little more reminder that, again, you may be required to provide more time off if they exhaust their time under PDL. So, if a physician or a healthcare provider deems the employee disabled and they cannot work during their pregnancy, under the vast majority of circumstances, the employer simply has to provide the time off. And some of the things that may come up that may require somebody to be off work are listed here: postnatal care, bed rest, diabetes, hypertension, preeclampsia, childbirth. And one of the things that you need to remember is that this time can be either before the pregnancy or after, before the birth or after the birth. As long as the employee is deemed disabled, it would be covered under PDL. So what does the employee have a right to come back in terms of their position? They have to be returned to their exact same position. And the employer doesn't have an obligation to put that in writing, but if an employee requests the guarantee in writing, the employer, again, must put it in writing and provide the letter to the employee. There are some, and there are very limited circumstances where an employer does not have to return the employee back to their position, or in this case, maybe there is no job because they were terminated for reasons that were unrelated to the leave. So an example of this would be a company's determined that they need to lay off employees in the next 6 months. And in those 6 months, they have had meetings and there's emails, they've done analysis of the positions, and then in month 5, so a month before the layoffs, the employee goes out on leave and her position is eliminated. In this case, the employer can easily establish that the termination was not due to the leave, and they do have documentation that this was going to happen and that they can substantiate, again, that this had nothing to do with the leave. But again, those cases are very, very far and few in between, and we really recommend you either working with your legal counsel or and or your HR department to ensure that if you are doing a termination, that, everything is in line. Let's see. So an employer may not require the use of vacation or paid time off during PDL. So if you use a paid time off system for the purposes of, again, PDL, you cannot force it out. So no vacation, no paid time off. What you can do is require the use of sick leave, and that can only be when the employee is not receiving any other form of payment. So an example of that would be the first week waiting period. They are not receiving benefits from SDI, and so you can force out, if they have the accruals, the 1 week of sick leave. The moment that an employee receives payment from any other vehicles, then the employer is not able to force out any more sick time that the employee may have accrued. And with that, I'll pass it back to Jeanine.
All right, good. I'm a lawyer. I can't, it's like painful for me to be quiet. So I'm going to talk quickly about disability and leaves of absence, and Sandra touched on this a bit. Overline or underline everything that we're dealing with when it comes to, my animation is not showing up. Hopefully it's loading on your screens. When we're talking about leaves of absence, there's always kind of this undercurrent of the ADA and FEHA. There we go. Whew, okay. I'm old. I can't do technology. So we want to keep in mind that the ADA, the Americans with Disabilities Act, and FEHA, I'm sorry, my apologies to everyone. I'm going to go ahead and speak and then just, there we go. Okay, hopefully I didn't press it too many times. Covers every employer in California that has 5 or more employees. So once a company has 5 or more employees, they're covered by California's Fair Employment and Housing Act. And then if you have 15 or more employees, you're also covered by the Americans with Disabilities Act. And those acts require that employers reasonably accommodate disabled individuals in hiring, firing, benefits, and other terms, conditions, and privileges of employment. So if you're not covered by FMLA or CFRA, then you're always going to be mindful of the disability rules when it comes to leaves of absence, but you also need to be mindful of those rules when someone has exhausted their FMLA or CFRA or PDL or the other leaves of absences they may be entitled to. So you always need to keep this rule in mind once you've hit that threshold of 5 employees. And when you get to 50 employees, you do not just ignore it because it can still come into play. And so that rule protects as I said before, protects qualified individuals with a disability. And then this is the definition of what a qualified individual with a disability is, who the basic thing is with or without a reasonable accommodation, that person can perform the essential functions of the employment position. And sometimes that means that it's an easier in-the-moment type of thing. I can do this job if you get me a monitor that will actually make it so I can actually see the words on the page. And if I have that, I can do everything else about this job. Things like that are the easy way to think about reasonable accommodations. Or if I'm going to have this job, I need to make it so that there's a ramp for me to get up to where I'm supposed to be because I can't go upstairs. But as the government agencies and as case law has evolved, and as people have realized how people heal and are able to come back from conditions, we've learned that additional time off or some time off could be the reasonable accommodation that is necessary to get the person back to performing the essential functions of their job. And I'm sorry, see, I was excited and I didn't press forward. So a reasonable accommodation is a modification or adjustment in the job. Now, when it comes to leaves of absence, a leave of absence with that is a reasonable amount of time can be a reasonable accommodation. And when I say a reasonable amount of time, it has to be where the medical provider has said, my patient needs until X date, and then he or she will be able to come back to work. Okay, that's reasonable because an end date has been given. Now, it can't be, right, as I'm seeing here today, it can't be in January of 2025 this employee can come back, because that's not reasonable. But it can be 3 months, it can be even 6 months. It can be that the doctor says 3 months, but we're all kind of sitting there and we may think, it's going to take 4 months at least. it doesn't matter. We're going to rely upon that doctor's note, and that's reasonable. And multiple doctor's notes where there's extensions can also be seen as reasonable. So that's the accommodation. So you need to keep that in mind when you aren't at 50 employees, or like I said, if someone has exhausted their FMLA leave and the doctor says this person just needs 2-3 more weeks, then because they've set a reasonable time limit, that could be seen as a required reasonable accommodation that you as an employer need to make. So you don't want to be quick off the gun. This person was supposed to be back on March 2nd. It is 10:30 a.m. and they are not here. We're going to fire them. No, there's those other magic words you've probably heard drummed into us all about the need to engage in an interactive dialogue. You can't just cut the cord. You have to find out, hey, are you coming back? Or you're supposed to come back today. What's going on? And if they say I need more time, you say, get me a doctor's note, as we'll talk about. That's also, and then to circle back to what Sandra said, that there's all those, what used to be kind of, some employers took advantage of what we're seeing as gray areas between if a pregnant woman went off work because of complications from her pregnancy, and then she ran out of pregnancy disability leave, but still needed about 2 more months before she was even going to give birth. And so some employers were like, well, there's no more protected leave, you're fired, which kind of goes against the whole philosophy by the, as I said, the Equal Employment Opportunity Commission and the Fair Employment and Housing Department and the government and courts. They say no, because that you can't fire somebody during that period. They've run out of their pregnancy disability leave. So when that happened, they're no longer entitled to that exact same position when they come back, but they're still entitled to protected time off. And so you don't fire them. They're on this protected leave of absence under the disability laws. And then it may be that if they meet the rules, they have the baby, everything's fine, that they're entitled to baby bonding leave under the CFRA leave if they meet the eligibility requirements. And then when they return to that, they return under the umbrella of the CFRA, and so now they're entitled to the same or equivalent position. If we go to a different scenario and someone had some terrible surgery and the only leave they were eligible for was this disability leave, then what they're entitled to come back to is a position. Okay, so you have exact same position for pregnancy, same or equivalent for your CFRA, FMLA, and then for disability, it's kind of a position. Although I would strongly caution you from taking my words too literally on that. You don't say, oh, we're going to punish you and give you the worst position. It's just that you get a little bit of leeway, but try and put them back into the same or equivalent position. And I think that's my excitement on that. Oh, we did have a change. We're constantly getting little modifications to FEHA. You can't, if someone asks you to take time off or some other accommodation for religion or disability, if they ask for a bigger monitor or if they ask to take a leave of absence, you can't, if you determine that they don't need that bigger monitor, they just wanted one, for example, you can't then punish the person for having asked. You get to ask. So just be mindful of that. And I think that's it. But always keep this rule in mind. Always, so this just goes to my first theme of always just go back and go through your checklist of rules. And then your other theme, which makes me seem like the soft-hearted person that I am, but you always kind of want to say, what can I do to put this person on a protected leave? Because that's what the government and the courts want. What do we have here to put this person under? And in the end, it is better for you as employers because your money stays with you and it doesn't go to my people, defense attorneys. Okay, and now, Sandra, hopefully you can do these slides better than me.
Okay, thanks, Jeanine. So I want to talk a few minutes, maybe more than a few minutes, because it's a really important topic on medical certificates and focusing on not receiving medical certificates or if there's any confusion or clarification needed for the certificates. So an employee definitely has an obligation to return the med cert, and with that, the employer has limitations in obtaining it if the employee is not cooperating. So when does an employee need to get back a certificate? They technically have 15 days to turn in the completed healthcare provider certificate. If the certificate is never returned, the time off is not considered FMLA. If an employee does not return the certificate, the employer definitely has some obligations, and the next few things that I'm going to walk through, you definitely want to make sure that you document all the efforts that you've made to obtain the certificate in the event that you end up terminating the employee because they never turned it in. So one of the first things that you need to do is send a letter to the employee requesting the certificate and providing a new deadline because they missed that 15-day window. So I have in here a tight deadline is recommended, and then in talking to Jeanine, she said we want to be very generous. So we want to do both. We want to give a specific deadline. Maybe that's a week, because we don't want to extend it 3, 4, 5 weeks, but that is giving somebody enough time to call a doctor and get into an appointment or get a fax. So again, you do want to be very specific of what the deadline is. The letter doesn't have to, but it can reiterate what the consequences are of not returning the certificate within the time frame. One of the things that is really critical to remember, and I was just working with this earlier this week, is you want to make sure the means of communication are multiple, and it's the means of communication that you normally communicate with the employee. So for example, if I'm going to send a letter, I'd probably leave a message on their voicemail, send the letter. If the person has been out on leave and they have a personal email, I'd probably send it through the email as well, because we want to show that we made every effort to make sure that the employee received the information. What you don't want to do, and we have seen this before, is you shut down the employee's company email and then you send all the communication to their company email address. Well, obviously the employee's not going to get it, and it's not going to make for a good situation. As the employer, you should really allow the employee an opportunity to explain the delay and whether they've acted in good faith to obtain the certification. So an example of that may be that somebody is right at the 15 days or maybe at 13 days, and they reach out to you and say, you know what, my physician, and this actually happened this week, I'm working with someone to get a certificate, and their physician had a severe family emergency, and he's out of pocket all week. And so we've extended it through Monday. So you want to talk with the employee to see, are they making an effort, and what they're saying, does it make sense, and can you give them the extension? Another example would be the parent is sick, but now maybe their child has fallen ill and they need a couple of extra days. So you always want to give the opportunity to the employee to explain what the delay is. And always prior to terminating an employee, if you're not getting any response, so no phone call back, no email, no certificate, you definitely want to consult with your HR department, with your leave administrators, with your attorney, and just reevaluate the leave as a whole and determine if the best course of action is to terminate the employee or not. One of the best things that you can do is, and Jeanine spoke to this a little bit at the front, is have a checklist, have written procedures, and you want to make sure that you follow it consistently for all the employees. So if I have a medical certificate and it's not clear or I need some information, am I able to go and get clarification? And the answer on that is it depends, and if you can, it's very limited. So if you get a certificate and you don't understand what the information is or it's incomplete, you tell the employee what is needed. So for example, if you get a certificate that has no dates but just says so-and-so can't work, then you call the employee and say, we need actual dates. Can you please take the certificate back to your physician or your medical care provider and get that back to us? Another one that we see is certificates that say they need intermittent leave, they cannot work full time. Well, as the employer, we don't know what not working full-time means. That could be leaving an hour early each day, or it could be 2 days a week. So we need the employee to go back and have their physician write on the note exactly what is meant by intermittent time. The default should always be to allow sufficient time, again, to produce the certificate and be able to designate the time as protected. In the event that the employee doesn't provide the certification ever, and again, the employee goes MIA, then that time is not designated as FMLA, and then the employer can defer to their other time and attendance rules and determine kind of what next steps are. So the CFRA and the FMLA, they have different regulations in terms of what you can and can't do with a medical certificate. And one of the things that's really important is your supervisors and your managers should not be clarifying medical certification. It really needs to be done by your leave administrator or the HR manager or the leave specialist who is coordinating the leave. So under the CFRA, an employer is not allowed to contact the employee's healthcare provider. The CFRA requires an employer to allow the employee to cure any deficiencies with the healthcare provider. So that would be the example I gave previously. If the note isn't really clear, you have to go back to the employee, and the employee needs to go back to the doctor. An employer does have the ability to contact the healthcare provider to authenticate the employee's form. So let's say you get a form and it has a signature and maybe not a date and it doesn't have a stamp and you're just not really sure. The employer does have the ability to contact the healthcare provider and just say, we want to confirm that you provided, Sally Sue this note and this is what it said. And again, you are able to do that. When an employer needs clarification and authentication, the employer should allow the employee to do both of those at the same time, or to cure the deficiencies and then work with the healthcare provider after. So you want to give the employee the first opportunity. So just to recap on the CFRA, yes to authenticating, no to reaching out to a doctor for clarification. The FMLA is allowed to contact the employee's healthcare provider to authenticate and to obtain clarification. So clarification, again, means to understand the handwriting on the form or to understand what the response is on the med cert. Under the FMLA and the CFRA, an employer cannot ask for any additional information beyond what's required by the certificate form. So we don't want to be asking the gal on the phone, so what's really wrong, and do you think they're coming back, and well, what do they have, because I can't really tell by this note what illness they have. We, as the employer, are not able to ask any of those questions. And under the FMLA, if the certificate, again, can't be clarified, the employee is not willing to work with you, the employer cannot get clarification, then the employer has the option of denying that time as FMLA. And with that, I will pass it. Oh, actually, I'm sorry. It is my, Jeanine, paid time off and regulated leaves.
Awesome. So this is Jeanine again, and I'm just very quickly going to talk about paid time off because, again, what we're talking about today is the time off, the protections for the time off, which means you don't fire the person when they're on the time off or punish them for taking the time off. But then how do they get paid? Can you force out their PTO, their vacation, their sick leave? And we have that new underline, I like to use my comments about California paid sick leave, and it'll see there's a nice note here that says that the employee in some ways gets to choose when they're going to have their paid sick leave paid out. So the safest and most conservative approach is to permit an employee to use paid sick leave if requested, but not require that it be exhausted during CFRA leave. And then you have to remember that right after, or a few months after they enacted the paid sick leave law, they realized, oh my gosh, all these people we didn't clarify what to do about PTO. So if you're going to use PTO to satisfy the paid sick leave law, then you're using PTO to satisfy the paid sick leave law, and you need to abide by those rules. And so when you're looking at PTO for that, you need to, you need to consider it paid sick leave and follow the same rules in bullet 1. Then you get the added fun of when the person leaves, you have to consider PTO vacation. So that's the fun of PTO, is that it's kind of a blend. And then when you're talking about whether or not you can have the person draw down from their accrued paid time off banks, their sick leave or their vacation, you need to keep in mind whether or not the person is receiving SDI or PFL, paid family leave, which is a terrible name because it's not paid family leave, it's paid family wage replacement. So as you go to the next screen, there's also a great chart that talks about when and when you can't make people pull down from their accrued time off, their accrued paid time off, their accrued vacation, their accrued PTO, and their accrued paid sick leave. Now, when we say you can do it on this chart, you can't just spontaneously do it. You must have put into place a written policy that says that's what you're going to do, given people notice that you're going to either pull it down or not, or give the person discretion or not pursuant to the law. And that policy must have been distributed really before that particular person goes on leave, because it's remarkable how many employers, once they find that Joe goes out on leave, they suddenly want to put in a policy that does something that didn't apply to Jim. So you need to have decided what your policy is, make sure it complies with this chart, and then distribute it either in a formal handbook or just in a policy statement. So that is a great resource for you to look at that. I often get calls, or I'm addressing situations where people have what's called unlimited paid time off policies, and that's often in newer companies or companies where the HR professional is tearing their hair out over vacation, paid sick leave, and PTO administration. I just want to give a couple cautions about it because it does have an intersection with these protected time offs. And the first protection that Sandra reminded me about, or the first caution, is that when you call something, just because now I have this great acronym, I can call it UPTOP or, unlimited time off. Well, when you call it unlimited, remember we're talking about people that we get in trouble when we don't tell them they must take their rest break right now. It's like there's a certain maternal, paternal aspect to the employment relationship that we have to be mindful of. So if we call something unlimited, guess what? We're stuck with it being unlimited. We can't punish somebody because they took 14 days off in a row. Well, you said it was unlimited. It's like there was this great football player who played at Miami, and then he went to the Colts. And in football, they have these things called voluntary workouts. And he said Sports Illustrated, somebody was giving him all this grief because he didn't show up for the voluntary workouts. And he goes, I didn't do so hot at the University of Miami, but I'm pretty sure I know what voluntary means, right? It's like I know what voluntary means and I know what unlimited means. And unlimited means unlimited. So no accrual might be a better term, since what you're trying to do is give people freedom yet not have that accrued unpaid bank sitting there, or accrued bank. It's really something that should only apply to exempt employees, and we could spend a whole seminar on unlimited paid, look at that, no accrual, paid time off policies. And then you must be vigilant about how those things intersect with the protected time off. You must be aware that just because someone is off on their no accrued time off and you haven't heard from them and that's okay under your policy, well, when something goes awry and they haven't come back for weeks, maybe they were out on something that would have qualified them for a protected leave. And so you want to know that. First of all, you can start that clock running so they don't get 50 protected weeks of leave. And second of all, you want to make sure that you know what's going on and that they're under the protection so that a rogue manager doesn't punish them for not being there. So this is kind of, the previous slide was a resource to use. This is also just something to kind of alert you to issues with unlimited time off policies. And then am I doing the challenges? I hope so, because I love
I have the first one, and then
great.
You'll take it from there. So
awesome.
We just wanted to talk briefly about, again, some of the challenges that may come up when administering leaves. And one of them is, what if somebody tells you when they've just gone out on leave or in the middle of their leave that they are quitting, they are not coming back? And the question is, what obligations does an employer have? Because if if the company has a paid time off policy where they're paying someone to be out on leave and they have their benefits, they might say, well, my leave runs through, it's January, my leave runs through March 31st, so I'm quitting on April 1st. Well, the regulations actually say that if the employee truly has no intent of coming back, the notice that is provided to the employer, the date that it's provided can be the date of termination, not the date in the letter. So if an employer gets a resignation letter on January 15th, the termination date can be that day. So there might be circumstances, though, where an employee wants to come back, but they're not sure that they can. Well, that's different. An example might be somebody calls and says, I'm not sure if I'm going to be able to come back from leave because, for example, I can't find daycare, and I'm really trying, and I'm making every effort, and if I can't come back, or if I can't find daycare, I'm going to have to quit. Well, that doesn't meet the regulation. At that point, you cannot terminate the employee. You can't cut off benefits because they are trying to make an effort and they actually do want to come back to work. So just keep those in mind. You always want to get something in writing. You always want to respond back in writing that you've accepted their resignation and just verify what their date of termination is. And now Jeanine's going to talk a little bit about actually terminating an employee while on leave.
And I just want to make sure that you guys are aware of the time. I know I'm planning on you going for another 4 minutes and then leaving us a little bit of time to address some of the questions.
Perfect. So
Great,
I
thanks.
have 3 things, I think. So number 1, I want you to make sure that when you say, Sandra was specific when she said a letter, so you don't do anything unless you have a letter from the employee. You don't rely upon something you saw on Facebook or something that Barbara said over a barbecue everybody went to. It's only a letter, not what you think is going to happen. Number 2, terminating employees while on FMLA leave is fraught with hazards, because that's really the only place you can get in trouble is when you terminate someone while on FMLA. So Sandra also talked earlier about how for the previous 6 months there have been all these discussions about reorganization or realignment of everybody. Well, when that's happening, the person who's on FMLA leave is usually not entitled to a special circumstance other than different from someone who's still on the job. But again, it's just fraught with danger, and you really want to talk to your employment law counsel. So it's something that we have the slides here, and it's important to kind of get all of your information collected and then talk to your counsel or your consultant about whether or not it's the right move to terminate an employee while on FMLA leave. If someone had a performance problem, when they come back, you'll pick up from where they left off with that performance problem, but you don't sit there, as I deal with employers who often ruminate and then they just churn over it, and then they're like, it's unbearable. We have to fire the person. Well, the person hasn't been there for 8 weeks. Just relax. Nothing new has happened. If you open a drawer and find the person has embezzled millions of dollars from you while on leave, yeah, we could probably take some action against them, but that's the rare occasion. And then finally, when it comes to terminations, the real caution, and these are the magic words you want to be mindful of when you're talking to managers or executives who want to terminate the person, is when they decide, you know what, now that she's gone, we realize we don't really need her. Okay, no, that's not a valid basis for termination, and so you're just going to need to step back and follow all the rules about the protected leave and their right to return. The wonderful thing about human beings is if they're truly bad employees, they will live down to your expectations after they get back from leaves of absences and after their protections are gone, and you can just take a normal employment action. Don't tee up a home run for somebody by taking action against them while they're on leave. And that's an important thing. So you have those slides, and then the other part is what I talked about earlier, my last slide in this section, which is the after FMLA, the person needs more time off. You're just going to talk about, you're going to go back and look, is this somebody who could still have some ADA, FEHA, disability leave, et cetera, and talk through that. And yes, not all injuries or illnesses fall under it, but you want to kind of take a look to see, is this something where continuing the leave for a little bit longer is the safer bet for everybody involved, including the employer. And that's it. Thank you, Sandra. Your turn.
So I just have one slide that I wanted to review real quickly is for larger organizations, they might have a whole leave administration department. They might have a very sophisticated software. But if you've got, 45, 40 to 100, 200 employees, you may not have those resources. And these may sound like very simple solutions, but they actually are very, very helpful and they're very effective. So the first one is have HR always administer all your leaves. Establish a phone line and a voicemail that's just set up for the leaves. This eliminates it being someone's personal voicemail, their personal email, and it also may have employees feel more comfortable in reaching out to the leave department. Create a leave request form. A lot of times you can get all the information that you need on this form and you don't have to go back and forth with the employee, and then you save it historically in the file, which at times can come in very handy. Many things that need to take place, very task-oriented. Create a checklist for all the tasks that would go in the file as well. Create written procedures to ensure consistency, and again, to make sure that you're following them. It's an excellent thing to do. And then you can also create a database in-house or a spreadsheet where you can have all the information as well. And again, there's always the option of having leave administration services and leave administration software. And I will wrap it up now. I had two more slides that you can review. They were just, again, recommendations when going out on leave. They're things that we've already talked about, but that was the last two slides. And with that, our presentation is over, and I'll pass it back to Amy.
Great. Thanks, guys. I think I should have known that we should have planned on this being an hour-and-a-half session because, honestly, with leaves, it could be a whole-day seminar. So I appreciate you guys trying to condense all this information into 45, 50 minutes. And we have far more questions than we're going to get to right now. We will respond to other people's questions if we're not going to get to them now offline. But one of the things that came up a couple of times was with regard to the FMLA eligibility, 50-plus employees, is there a mile radius of the headquarters, or is that just 50 employees anywhere?
It's 50 employees within a 75-mile radius of that person's work site. So it doesn't matter if headquarters is in Boise. If that employee is surrounded within 75 miles of 50 employees for the same company, we would consider them to be eligible under that rule.
Great, thank you. That's a good clarification. There was another clarification that was asked for CFRA, which whether it applies to all employees regardless of size or if it is the 50-plus employees, because they seem to have heard conflicting information that it wouldn't apply to small employers.
It does not apply to small employers. You do have to be over 50. The eligibility requirements on the employer side and the employee side are exactly the same as FMLA. And one thing that is really helpful to remember is FMLA and CFRA, they're basically the same and they run concurrently in every circumstance except for pregnancy. So you have to meet the same qualifications for both.
Okay, great. If an employee has used all 12 weeks of their leave for a personal illness, and then at some point later in the year, another incident happens, and are they eligible to start again with the leave?
All right.
So if they've exhausted, if they've exhausted their FMLA/CFRA, the first thing you want to determine is, are there any obligations that the employer has under a different leave or accommodation? And the biggest ones that we talked about are the ADA and the FEHA. And those are very gray laws to interpret, but that's the first thing that you want to do, because many times you do have to accommodate under the ADA, and accommodation can be additional time off.
Okay, great. And, you know, for everyone who does have questions about leaves, this is complicated stuff, which is why there's people who specialize in it, like, you know, HR Options and Sandra and Jeanine DeBacker. So when you're in doubt with leaves or how that's affecting your workforce, I highly recommend that you reach out to a professional, you know, and the clarification could save you a lot of pain and cost down the road. One last question is with regard to the unlimited time off. And I like the idea of doing a separate webcast in the near future that just covers the unlimited time off, because so many companies are doing that. The question that came up was, how would an employer with unlimited time off specify when an employee needs to start using a state or federal leave of absence?
That's a great question. You know, when we do, the thing that people fall into is they think they're going to have this, and I'm going to use unlimited time off, and they just kind of say it out to the wind. It's still good to have a policy, and in that policy you're going to say, if it really is unlimited, meaning you don't really have to tell us too much about it until we hit like a 10 business day mark. And then we're going to kick in and we're going to talk about FMLA. You put that all into a policy. And so we usually do a 2-week mark. And I know this is kind of circling around the question, but that's what you do. You're going to put it into a written policy that defines when people have to go pull down SDI, when they have to go get paid family leave. You can have them integrate it where they get paid family leave, and then you're going to make up the difference. And if you're in San Francisco, you have to. But so it's all part of a written policy, and it's not an encyclopedia. It's a couple pages, but you really have to think it through and think through what will work for your workplace.
Great. Well, we are out of time. I want to encourage all of you participants to please just take a moment and click on the evaluation widget at the bottom of your screen, or it may have popped up for you on your screen. Just take a minute to give us your feedback. We'd appreciate that. Thank you, Jeanine and Sandra, for all of your time in preparing this webcast and for your time online with us now.
Thank you, Amy.
I want to thank you all for joining us today, and we look forward to seeing you online at future webinars. Hope you all have a great day. Thanks, guys.
Thank you.